The case of City of London Building Society against Flegg provides a useful illustration of how the doctrine of overreaching works. In very simplified terms, overreaching is a mechanism in our land registration system which allows a subsequent purchaser, in the case of a sale of land, or a bank in the case of a mortgage, to obtain title to land free of any qualifying equitable interests. Before going to Flegg itself, let's look at how overreaching works in more detail. First off, we have a plot of registered land. For the purposes of overreaching, the legal owner of the land would be the holder of the leasehold or the freehold estate of the land, because it is these two estates which qualify as legal estates for the purposes of Section 2, subsection 1 and Section 1, subsection 1 of the Law of Property Act 1925. Now, assume also that in the same plot of land, another person owns not a legal interest but an equitable interest in the same property. It has to be noted, however, that not all equitable interests can be overreached. They must not fall under any of the exclusions under Section 2, subsection 3, such as an equitable easement or a restrictive covenant. The most common example of an equitable interest being overreached, and will be the one that we will focus on in this video, is a beneficiary's interest under a trust. In this case, therefore, the legal owner is said to hold the property on trust for the benefit of the beneficiary, the equitable interest holder. The legal owner therefore becomes the trustee of that trust. Section 2, subsection 1, paragraph 2 provides the overreaching mechanism by which a trustee's conveyance can operate to overreach the equitable interests. This paragraph reads as follows: "A conveyance to a purchaser of a legal estate and land shall overreach any equitable interest or power affecting that estate, whether or not he has notice thereof, if the conveyance is made by trustees of land, and the equitable interest is capable of being overreached, and the requirements of Section 27 of this Act respecting the payment of capital money arising on such a conveyance are complied with." Now, let's look at all of these elements in turn. First off, Section 205, paragraph 1, subparagraph 2 of the Law of Property Act makes clear that a conveyance can also include the grant of a mortgage. So, if a trustee sells title to land or grants a mortgage over the land in favor of a mortgagee such as a bank, then this would count as a qualifying conveyance for the purposes of overreaching. This is echoed by Section 205, paragraph 1, subparagraph 21, which states that the term purchaser used in Section 2 of the Law of Property Act can also include a mortgagee, and not just a purchaser of legal title. And finally, we come to the requirement of monies being paid to trustees. Section 27 states that a valid receipt of purchase monies or mortgage monies can only be executed by 2 or more trustees. And this is echoed in Section 2, subsection 1, paragraph 2, where the word trustees is used in plural. In other words, for overreaching to occur so that the purchaser or the mortgagee can obtain legal title to the property without having to worry about any residual equitable interest encumbering the same land, then they must make sure that any capital monies is being paid to at least 2 trustees or a trust corporation. If all these requirements are satisfied, then overreaching will work its statutory magic by detaching the equitable interest from the land. Instead, the beneficiary's equitable interest will be transposed onto the sale or mortgage proceeds, and thus they will be entitled in equity to a contribution of those sale proceeds. Now let's turn to the facts of Flegg. In 1977, a couple purchased a house called Bleak House, with half the purchase price paid for by the wife's parents. Bleak House was registered, however, at law under the couple's name only. In equity, therefore, the parents became beneficiaries of the title to Bleak House under a resulting trust, of which the couple were the trustees. 5 years down the road, the couple had experienced money problems and decided to remortgage Bleak House in favor of City of London Building Society without letting the wife's parents know. The couple eventually defaulted in paying those installments due under the mortgage, and so the building society sought possession of the house. The parents, who were at the time living in Bleak House, tried to stop the building society from seizing the house on the grounds that they were in occupation of the house pursuant to their beneficial interests at the time when the couple made the mortgage, and therefore they had an overriding interest under a provision which may be considered as equivalent to Section 29 2A paragraph 2 of the now Land Registration Act 2002, which means that that overriding interest of the parents took priority over the building society's alleged mortgage. The building society, on the other hand, argued that the parents' beneficial interest in Bleak House had already been overreached when the mortgage was created, even though it was done so without their consent. And so the parents' beneficial interest, they argued, had no longer subsisted. Faced with these two competing stances as to how the overreaching mechanism worked and how these two proprietary rights would rank amongst each other, the court had held that the building society would win, and therefore they could seize possession of the house without having to worry about any equitable interests encumbering the house. And that was because the parents' beneficial interest in the house had already been overreached. All the different elements of the overreaching mechanism under the Law of Property Act had been satisfied. Let's see why. The freehold title to Bleak House was registered under the names of the couple, and as mentioned, is a qualifying legal estate pursuant to Sections 1 subsection 1 and 2 subsection 1 of the Law of Property Act. Due to the contributions made by the wife's parents acquired a beneficial interest to title to Bleak House. They were therefore beneficiaries of a trust, whereas the registered owners at law, namely the couple, were the trustees. And as we mentioned, Section 2.1 allows for overreaching to take place in the case of a beneficial interest under a trust, as it's not an excluded equitable interest under Section 2 subsection 3. Next, the couple granted a mortgage in favor of the building society, and as Section 205 of the Property Act states, a grant of a mortgage is a kind of transaction which can activate overreaching. Finally, when the couple remortgaged the house, the mortgage monies were paid to both of them, and therefore they satisfied the requirement that monies be paid to two trustees or more. All the statutory requirements for overreaching had been satisfied, and therefore the parents' beneficial interest under Bleak House was detached. Although this result seems harsh on the parents, Lord Oliver reminds us of the policy rationale behind overreaching. He states that, had the building society lost in this case, the legislative policy of the Law of Property Act 1925 of keeping the interests of beneficiaries behind the curtain and confining the investigation of title to the devolution of the legal estate will have been substantially reversed by judicial decision, and financial institutions advancing money on the security of land, like banks and building societies, will face unsuspected hazards. This was echoed by Lord Templeman, who states that one of the main objectives of the 1925 Act was to effect a compromise between, on the one hand, the interest of the public in securing that land held on trust is freely marketable, and on the other hand, the interest of the beneficiaries in preserving their rights under the trust. The compromise that Parliament eventually agreed upon was that under the Act, the protection, and the only protection of the beneficiaries, is that capital money must be paid to at least two trustees. Applying all this to the facts of this case, he says, the parents claimed to be entitled to overriding interest because they were in actual occupation of Bleak House on the date of the legal charge. But the interest of the parents cannot at one and the same time be overreached and therefore overridden, and at the same time be overriding interest. The building society also cannot at one and the same time take free from all the interests of the parents, yet at the same time be subject to some of those interests. The right of the parents to be and remain in actual occupation of Bleak House ceased when their interests were overreached by the legal charge granted over Bleak House in favor of the building society.